everybody. We just wanted to note for you that this interview touches on some sensitive topics, including rape and sexual assault.
If this topic is not for you, we totally understand. Join us next time. Also, if you choose to stick with us, please know that the opinions we share here and the things we talk about don't necessarily reflect our professional opinions or those of our employers. This is something we just wanted to share with you. We hope you enjoy. Welcome to Drinks with Defenders. I'm Addie B. Plate.
And I'm Kayla Murphy. We're two law school friends turned criminal defense attorneys turned podcast hosts.
We're here in this space because we now work in separate offices and miss collaborating with each other.
We've been talking about creating a podcast for years where we talk about the complexities of the criminal justice system, the aspects of it that we grapple with, and the importance of what we do.
At the end of a long work week, we want to sit down, have a drink with each other, and talk about the rabbit holes of criminal defense, just like we always have. So let's get into it. Cheers!
Who?
Ain't mine. I mean, I painted it.
Let's see. Oh, it is so nice.
Yeah, it looks
Oh my
good.
God.
It is Faith's office that she's letting me borrow for the day.
Well, it's cute as fuck. You can tell you live with a woman now. I love that for you.
Yeah, amen to that.
Also,
Amen
Kayla, I
to
didn't
that.
mean to talk over you, but I'm good. How are you? How are things?
Oh gosh, no, you're fine. That was definitely worth like bringing attention to. I did not even appreciate that. I'm fine. I'm good. You know how it is now, I'm sure, having your own practice, right? Are you still practicing on your own?
Yes,
Yeah, it's
I'm
like it just
literally.
fluctuates.
Yeah, I'm doing it. I'm only doing it part time. So like I only take on stuff as needed, but I'm in the middle. I did an operating agreement for an organization that like three friends of mine started, like a business they started together, and now their business is falling apart. So I am having to advise them on, like, two of them quit, the other one wants to keep it going. And so that's literally what I'm like editing right now. It's like this email of like, okay, well, you have no rights in this business anymore because you've left it. So this is all what we agreed upon 2 years ago or 3 years ago when I wrote this. And like, this is how it works now. So it's been a little tough because I'm having to tell my friends like, hey, yeah, I know that like we're friends, but also I'm the lawyer for this business. I'm not the lawyer for either, like any of you. Like I wrote this in the best interest of this business, and now we're all seeing that play out. So it's tough, but everybody gets it. But it's just like they've got bad blood in there, and I don't want any part of that.
This is like giving succession.
Yeah, it's really, and it shouldn't. Like I don't know. It's the whole thing is just, it's tough, and they all want to go their separate ways, and it's fine. But they're now starting to nitpick things in the agreement of like, well, why does this provision apply to this other part? Because this sentence is under the death, incompetency, or bankruptcy of our members section. And I'm like, well, this provision says like, if this is invoked at all in the agreement, this is what applies. You're invoking this other part of the agreement, so this applies. So it's, it's fun to have to, get to flex your education sometimes of like, yeah, no, I'm right. I'm sorry.
Tough business, man.
It totally is.
Tough.
How's yours going?
It's good. It's good. Making the most money I've ever made, and
Fuck yeah,
working the least amount of hours I've ever worked. So that's the dream, right?
That's amazing.
But yeah, it's great. Certain weeks are like, court every day and it sucks. But those weeks where I just have like, you know what I mean? And I can take extra time off. It's totally worth it. I love the freedom.
Yeah. Are you like doing all that from home too?
Yes. Yeah. I have an office where I can like go meet with clients if I want to, but more often than not, I'm home with my 3 babies. What about
Yeah.
you?
I'm totally work from home. Like Penn State for me now is all work from home. So I do have to go to campus like 1 week every quarter, which is different than what I had to do for UO. Like they always were like, don't come out here. Mostly they didn't want to pay for me to come out there. But Penn State will have me come out 1 week every quarter and we'll get a bunch of in-person stuff done. Like I'm going the first week in May and we're doing a retreat in our office. And then, we're doing like our monthly staff meeting. We're turning into like a cornhole tournament. We're just like, we're just playing cornhole at our retreat that day. And then I'm having a retreat with all of my investigators and we're doing like some updated training and I'm going to make them start recording all of their interviews. So it's going to be a pretty fun time.
Can you explain for our listeners what you do?
Yeah. I'm the Title IX coordinator at the Penn State University. They're very clear that cool. the goes in front of that. But I just started there in November, first part of November. So my whole job is to make sure that the Penn State University system, which is about 20 campuses, I think. I can never remember the exact number, but they've got like 20 campuses outside of their main campus and outside of our entirely online campus. They have a online programs called World Campus, Penn State World Campus. And so for all of these campuses, I'm responsible for Title IX compliance. So I have to make sure that we are upholding Title IX, which officially protects gender equity in higher education. So it started out as an athletics focused bill. It started out to get more women into higher education. That was the whole goal. And now it's kind of evolved into still, making sure that we have equal access to education regardless of your gender, but it also covers sexual assault prevention. So a lot of my work is overseeing, I do oversee athletic side of things, but my day-to-day work all revolves around investigations and adjudications of certain offenses. So sexual assault is in there. I also do sexual harassment, dating violence, domestic violence, stalking. That's kind of all of our Title IX offenses, but we have other offenses that we protect in addition to those. So we have sex-based harassment, we have gender harassment, we just have straight up discrimination and harassment and retaliation. So I oversee our entire adjudication process for that. So from the report coming in all the way through a decision being made, I oversee all of that now.
How does that affect you? Do you feel like you're more jaded? Is it really draining?
I don't know. I mean, it's kind of hard to say because the job I had before this, I was an attorney representing students in those processes. So I worked we call them respondents. We don't call them defendants in the student conduct and Title IX field. But I worked exclusively with people accused of doing something wrong. And I represented them in student conduct cases and Title IX and all kinds of stuff. So I did that work for 3 years. And that felt more draining than this now. I'm still in the weeds a lot with cases. I'm actually, as the Title IX coordinator, federal regulations prevent me from being able to do certain things. So I can't serve as an investigator on a case. I can't serve as a decision maker in a case. I can't have anything to do with appeals. I am the neutral person at the top of all of this process. And I used to be the attorney who very much had a side that I was representing and defending. So this is different just from that lens because the work is less personal. I feel like, when you represent a client, and as you know, and you get to know them and you understand what they are going through outside of being, interviewed for a case or sitting in a hearing or something like that, you don't really, in the position I'm in now, I'm aware that that's the experience that people are having when they're entering this process, but I'm not the one having to talk them through all of that or having to be part of that for them. Having that experience is part of the reason why they brought me into this job is because I would know how at least, one side of this case feels when they experience it. But for the most part, I really feel like it's a much easier place to be because I get to be the neutral party. My whole job is making sure that our process is fair and equitable and accessible for everybody. It doesn't matter if you're the person who's experienced the violence or the hardship, or if you're the person being accused of it. Everybody has to have equal access. And so the Libra in me really loves that balance and getting to be the person that upholds that balance.
That's amazing. I'm so curious as to your thoughts on how your job or just like your day to day, I guess, could be impacted with this upcoming administration. And we can cut this and we don't have to talk about it if you're not comfortable. But yeah, I was just reading through Project 2025, which we can circle back to later, but just kind of about their vision for the Department of Education. And it's fascinating. So I would just love to hear your thoughts to the extent you're comfortable.
Yeah, no, I'm happy to share my personal thoughts, and none of these thoughts reflect my employer. That's the disclaimer I'll give up front, which I think we're all pretty good about doing that. But yeah, I just from my perspective, what they're doing with the Department of Education is going to make things harder for us in certain regards, but also might not change my day-to-day work very much. So it's kind of twofold, right? They want to close the Department of Education. They made that super clear, but they want to take all of these responsibilities that the Department of Education has and put them in different executive agencies. So they want all the student loan stuff to be done by the Treasury. They want Title IX compliance and Title VI investigations. They want all of that to move over to the Department of Justice. And so right now, on paper, it doesn't really matter who tells me I have to enforce Title IX on my campus. I still have to do it. So, at a baseline, I don't see that affecting us in that regard. That being said, on a more holistic view, there's lots of different, like the Office of Civil Rights exists in the Department of Education, and they're the ones that enforce Title IX and Title VI. So if you're in an institution that's under investigation for one of those things, which I think I don't remember, I think it was a couple weeks ago now, maybe, they sent out the Department of Education. Yeah, it's from March 10th, I guess. So I guess just the last week. The Department of Education sent out an email that they're now investigating 60 universities for potential Title VI violations. So there's a whole list of these institutions, and they're not just left-leaning institutions. There are schools. I mean, there's a lot of schools on here, a lot of University of California schools, right? But there's a lot of schools on here that are, there's some schools that are from the middle of nowhere that are getting flagged for this. So I'm not quite sure what's going on with these investigations.
I'm so sorry to interrupt. Would you mind telling us like what Title VI and Title IX are?
Yeah. So Title VI covers it prevents discrimination and harassment based on your religion or national origin. So specifically what Title VI is, what they use Title VI to focus on these days is anti-Semitic behavior on college campuses. So,
I see.
Yeah. So there's been, over the last couple of years, even before Trump got in office, if the Biden administration was initiating a lot of Title VI investigations, like a lot of these schools like Columbia and MIT and Harvard, their presidents were all dragged in front of Senate committees and House committees to say how they were protecting Jewish students on their campuses. That was all done under the Biden administration. So
that's true.
This is not anything new. This is still a response to the unrest about the war between Palestine and Israel. That's where all of this is coming from. Is whether again, just from the neutral perspective, were any of these protests or any of these pro-Palestinian demonstrations or activities going on campus, was it creating a hostile environment for students of Jewish ancestry or religion? And in some cases, the demonstrations could have gone outside your First Amendment protections. There's a whole lot of conversation about whether it is or isn't. But if you are exceeding your free speech and your free expression rights to the detriment of somebody because of their religion or national origin, like being Jewish, either being Jewish by birth or Jewish by religion or both, Title VI is how you're protected on college campuses. Title IX protects it protects your access to higher education based on your gender. And there's a whole lot of conversations about how are we even defining gender under Title IX. The Biden administration wanted to expand gender to include transgender status, sexual orientation, and gender identity, which is what the Supreme Court did under Title VII for workplace discrimination. You can't be discriminated in the workplace under Title VII based on your sex. But the Bostock decision in the Supreme Court under a conservative court, what we have now, this case came out in like 2019 or 20. No, this case came out in 2020, I think, didn't it? Yeah. But they said that sex includes gender expression, gender identity, sexual orientation, transgender status. Biden's administration tried to apply that to Title IX and were unsuccessful. So Title IX still just protects your biological sex. So your female identified or male identified sex assigned at birth, that's what's protected under Title IX.
I have so many questions for you. Like, okay, I feel like this is a little random, forgive me, but I am just having this flashback as you're talking about this of being in line at the U of O where we went to law school, in the Starbucks line, in the the big building. Mm-hmm. Thank you. Yes.
Yeah.
And there was this guy and he was creeping behind this woman who was in line, and I could tell that he was trying to like take like a sneaky picture of her, like from behind. She was wearing like yoga pants, and I was just so alarmed. I like just did not know what to do. I just like got out of the line and I was like, "Hey, stop that!" or something. And he like went outside, and it was just like adrenaline. I like followed him, and then there was this man who appeared to be unhoused, and he was like, "What happened?" And I was like, he was trying to take pictures of this woman, and by this time she was out there too, and then he chased him. I don't know what happened after that.
Oh damn.
So I guess my question is do you have cases like that? Is that like a thing you've encountered, guys that are trying to take creeper shots of women at universities?
Oh, yeah. There's
all
kinds of stuff. So it differs campus to campus, right? But Title IX gives us a specific set of behaviors that we have to investigate and prevent, do our best to prevent. And if they occur, we have to investigate and adjudicate those in a certain way. So those offenses are also given to us in the Violence Against Women's Act, which they've not renamed that, I don't think, but they keep recertifying it in Congress, which is good. There was some debate about it a few years ago, but they keep recertifying it. But the definitions we get from VAWA, the Violence Against Women's Act, so those definitions are what we use in Title IX to define like what is sexual harassment, what is sexual assault, what is stalking, all that stuff. And there's also the Jeannie-Cleary Act, which is a campus safety law that we have to follow as well. And that more has to do with how we track these kinds of things that happen on campus. So there are certain crimes that if they happen in your Cleary jurisdiction, whether it's on campus or campus adjacent, having to explain Cleary jurisdiction is not within my wheelhouse because I'm not the Cleary professional, but there are some off-campus locations that can count as places where you have to count if a crime has occurred. And then every year, institutions have to publish their annual safety report, which documents all of the crimes that have happened under Cleary jurisdiction. And so Cleary also defines stalking and sexual assault and sexual harassment. We actually, at Penn State, we have this manual and it's tabbed up and tells us what is a Cleary crime, how do we define it, how do we track it. My office has a meeting with campus police once a month and we go through our numbers to make sure that our Cleary numbers are matching with them. But they also use the VAWA definitions for domestic violence, dating violence, and stalking. So essentially we have 3 different sets of federal law that govern how we define some things in our policy. But there are some behaviors that happen that might not be Title IX behaviors. Like what you're describing may not be a Title IX offense. It could count as sexual exploitation, like taking photos of someone and it, again, kind of depends. Sexual exploitation is not defined under Title IX. So you could have it defined under your non-Title IX policy, which like sexual exploitation could cover like, distributing someone's nudes. If you got someone's nudes and you're sending them out, or posting them online or something, that counts as sexual exploitation. That could potentially count as exploitation as well, just based on the context of it.
Do you see cases like that often on campuses?
Yeah, we see sexual exploitation all the time. Sometimes it covers like, and this is a little iffy, but at my institution, if you are in a dorm room and you have a roommate, like you have the same bedroom, you got 2 twin beds in one bedroom. If somebody's masturbating in front of the other person and the person not masturbating has made it clear that they don't want you masturbating in front of them, that can be considered sex exploitation under our policy, because we, would say like, you can't engage in this sexual act in front of someone who doesn't want to have that act occurring in front of them. So,
for sure. If it was on a bus, there would be no question.
100%. And we get those all the time. And sometimes it's actually like, I've told my roommate to stop doing this in front of me. Sometimes it's just like, your roommate's really horny and they're just trying to do it secretly under the covers at 2 a.m. Like sometimes it's a roommate conflict. Sometimes it's a policy violation. It really just depends on the context.
Damn.
Yeah.
So nuanced.
It really is. And we see all kinds of bizarre behaviors. Like I unfortunately, like dating violence and domestic violence and sexual assaults, like those are the ones that we see most often. And that's what people think of, like on our, on college campuses. When you think about Title IX, you think about those kinds of violent behaviors. But sexual assault can be non-consensual touching. It could be non-consensual penetration. Some schools define it further than that, but for the most part, it's really those two. But any kind of unwanted touching in an intimate body part area. So that, I had a case. I don't remember what school I was at when I had this case. I feel like it was an early Penn State case, maybe. I don't remember. But I've seen cases where like students are standing in line to get into the football game and someone's behind them pushing their boner up against this other person, right? Like that's non-consensual touching. Like it's sexual assault, because if your boner is touching someone else's intimate body part, that's sexual assault. Especially if that person didn't consent to you doing that in line.
So like rubbing up against somebody's butt, even if clothed, would still be sufficient.
Yeah, it's groping, more or less. Like we have like over the clothes groping, under the clothes groping, like we would cover that too. Yeah. Yeah, it's bizarre.
Back to that, I'm so fascinated. So the jurisdictional thing you were discussing earlier, that's complicated. Is that like if a campus apartment would qualify as okay, gotcha.
Yeah, so Clery jurisdiction and Title IX jurisdiction are very different. So Clery's is very complicated and nuanced. Like there's the example they use sometimes is like if you have a fence that goes around your campus and there's a hole in that fence and students go in and out through that hole to go to this lot across the street to engage in illegal activities, whatever that might be, that could count as Clery jurisdiction, because that your students are going over there, that they have the access to do it, and there's no, like, about this and you're letting it happen kind of thing. That's the example. I don't know how applicable that is to every single college campus. Like it's still super nuanced. And some campuses decide like this is our Clery jurisdiction or this isn't. Like they make that call based on, it's a case by case basis on each campus. Title IX though is much easier, thankfully, which I'm so glad that I'm not the Clery person. Like I just do Title IX, but the Title IX jurisdiction is really easy. So it has to be in the United States. So that was also something that Biden wanted to change. He wanted to expand Title IX jurisdiction outside the U.S. But Title IX it has to happen in the U.S. And it has to either happen on campus or under substantial university control. So study away trips that happen domestically, like we had an incident fairly recently where the students went to the West Coast and were engaged in a study abroad trip where they were gone for 2 weeks or something as part of the class. If there's an assault that happens on that trip, some kind of Title IX violation, that's a Title IX, could be a Title IX offense because it's under our jurisdiction, because even though they weren't on campus, they were in the United States and we had substantial control because that was a university-sponsored trip. Same thing with athletics. If the athletes are traveling and something happens on that trip, that's could be considered Title IX jurisdiction. The other part of our jurisdiction is how severe the effect is on the person who experienced the harm. So Title IX, it has to be severe, pervasive, and objectively offensive. Those are the three qualifying criteria for the offense itself. And we really ascertain that from the person themselves. So most of the time, I would say a large majority of the time, if it's happening under our jurisdiction of on campus or under university control, we're usually treating it like Title IX because it's just safer to assume that it did have this impact on this person. But we don't have to make it a Title IX. We usually do. And at my institution and even at University of Oregon, we gave the same process for Title IX and non-Title IX offenses. So anything that happens off campus that's not a university-owned building, that would not be considered Title IX. So if you are renting an off-campus apartment and that apartment exclusively caters to students, right? Like they had these in Eugene all over the place. Like you lived in these apartments, it was marketed to students. Maybe they do individual leases for 4 bedrooms, right? Like they're trying to get student business in here. That is not a Title IX offense if an assault or stalking or domestic violence happens over there because it's not on campus and it's not under university control. If that same activity happens in a residence hall that the university owns or off-campus apartments that the university owns, that is Title IX jurisdiction. So that jurisdictional piece makes a difference when it comes to what kind of process do we have to afford to these people when we get to that phase.
What specific remedies do Title VI and Title IX offer that administrator at a university couldn't through some kind of misconduct action or discipline?
Yeah, so Title VI and Title VII require you to give specific
Title IX, I'm
procedural
sorry. Thank you.
Sorry, no. I said the wrong thing too. Title VI and Title IX. Yes, I said Title VII. That came out of nowhere. Title VI and Title IX. Yeah, we have to give certain procedures on campus when certain things happen, and that's a large piece of the controversy. Just like a little background for Title IX too. Title IX is like 16 words or something. It's not very long. Like the law itself is very short, but the regulations are created under the rulemaking process in the Department of Education. So all the administrative law stuff that we learn in law school, how a proposed regulation becomes a rule, not how a bill becomes a law, but very similar. You have to go through this whole notice and comment period. The government has to read every single comment that comes in, and then they publish these regulations. So the Title IX regulations are crazy influx. That's always a big point of contention. There wasn't really any Title IX regulations until 2011. And there was a Dear Colleague letter that came out. And these Dear Colleague letters are not enforceable under the law, but they basically said, here's how you should treat sexual assault on your campus. Then there were some Title IX regulations that went into place, but the biggest impact on the Title IX space was during Trump's presidency in 2020. He put out his version of it, or Betsy DeVos's version of the Title IX regulations, and it appears to be super respondent friendly, super friendly to the accused party. And I would have to explain a Dear Colleague letter. This is really only used in the Department of Education, which is really weird. But technically, any government agency, any executive branch agency, so the EPA, the Department of Defense, any of these executive agencies can put out a Dear Colleague letter. But the Department of Education uses them more than anybody else. And it's very similar to an executive order where it's them kind of making this statement about what needs to be done or what shouldn't be done or what their version of the rules are, them explaining their own rules. But following that 2011 letter about Title IX, courts have intervened and said this is not enforceable law. This is not enforceable regulation. It's not enforceable language from the government. So very similar to an executive order where it's, you're basically just posturing about what you want to happen in what you want your executive agencies to do. That's a version of the executive agency posturing for themselves, more or less. So it's really just like, hey, dear colleagues, here's how this is supposed to work. Or we've been getting a lot of questions about this. Here's the answer. But it's not enforceable in that way. We got a Dear Colleague letter from this Department of Education fairly recently. And I don't even know. I'm looking at my email to see if I saved it. I don't think I did. But we got a Dear Colleague letter in January, I think, from the Department of Education. And basically, we got a January one and a February one. I feel like there's been a couple, but the second one that they sent out said, like, if you're doing any illegal DEI activities on your campus, you're going to lose Title IX funding. But it's unenforceable. Like, there's literally a footnote in the Dear Colleague letter that says, like, this is our opinion as a Department of Education, but also this letter is not enforceable. Like, they're acknowledging that it's not enforceable, but they're just like sending out this stuff to scare colleges. So that's kind of what, I mean, in 2011, they didn't know that, right? They thought, like, we need some clarity on the law. We're going to give it. But then schools got pissed and said, like, how can you expect us to do all of these things you're asking us to do? And the court stepped in and said, yeah, you can't do that. So now if you want to have Title IX procedures to follow on a campus, you have to go through the full rulemaking process. So to kind of sum all of that up very shortly, the 2020 regulations from Trump's administration are viewed very friendly to respondents. As someone who's been deep in the Title IX regulations pretty much since they came out in 2020, I don't necessarily agree with that because there are a lot of complainant protections in there too. And these Title IX regulations level the playing field, I think, a bit for people who are accused of doing something wrong. But the big thing that it does that people don't like is it requires a live hearing with cross-examination. So you have to basically put on a mini trial every time that you have a Title IX case. So we have to assign advisors to our parties. They don't have to be attorneys, but if you give one side an attorney, you've got to give the other side an attorney. And then those advisors have to cross-examine the other party on their party's behalf. We don't let the parties talk to each other, but they can have their questions asked through their advisor. So that's the biggest thing that people kind of universally hate about Title IX is the live cross-examination and the confrontation at the live hearing.
How are you, Addie?
Oh my God, you guys, I've been moving. I've been fighting with Xfinity because my Wi-Fi is not working. Save actually early during Switch Offenders days when I had just moved into my place.
Mm-hmm.
When I first started, like right after I graduated law school, just getting Wi-Fi set up. Yeah, it's rough. I was on the phone with them forever earlier, and then they were like, oh, you need a new modem. And then now my Wi-Fi is not working. And I was like, this is not an issue with the modem. It was literally working at my previous place like yesterday. So this is a you problem. This is not a me problem. Figure it out. So
this podcast is not sponsored by Xfinity.
It is not. And
for damn sure.
And let me tell you, to echo you, my opinions do not match those of they're not necessarily those of my employer. But first and foremost, I am a hater. And Xfinity has made a hater out of me. So there you have it.
Oh yeah, they're
if
the
I
worst.
if I'm one thing, I am a hater. And that grudge of just how awful it is to deal with like the logistics of moving is one I will carry to my grave. So other than that, I'm good. So.
There's freedom in embracing the hater within you.
Oh, absolutely. And it's funny, Kristi, I want to like just comment on one thing you were saying earlier because I was thinking about it.
Wait, pause. Before you got on, Clark wants us to say what drink we're drinking.
Oh, yeah.
Yeah, and then we'll pick it back up.
I'm playing producer for him right now.
Please do. We've missed you. You're like...
I don't know why. I was the hang.
It's part of your role.
Just the accountability producer.
Oh, guest of the podcast. Welcome back. What are you drinking?
A Montucky Cold Snack.
Ooh, what is that?
Cute.
It's a beer. You never had these when you lived in Oregon? That was the first time I ever had them was when I lived in Oregon. It's like a they brew it in Montana, and it's just like a PBR adjacent, I think.
Ooh, okay.
Like it's like a trash. No offense. They have been supporting local nonprofits and charities since 2012. But it's like a beer that you buy and get like a shot of Fireball with for $5 or something like that.
Oh,
but it's really good. And during Pride Month, they make this a rainbow. So
super cute.
Yeah.
Okay.
Nice.
All right.
Is the unicorn always there?
Yes.
Mm-hmm.
I think technically it's just a horse.
Oh, never mind. Not as cute as I thought.
Fair.
So sorry.
Less of a sleigh without the unicorn. Kayla, what are you drinking? Let me guess. It's a Truly.
I
Is it the
know.
strawberry
Strawberry
lemonade?
lemonade.
Yeah.
I found a 6-pack of just these. It's always a good omen when that happens.
We love
Yeah.
we love the consistency.
Thank
It's
you.
great. You're welcome. You're welcome.
You started at a new office, Addie.
I did. And on
Right?
that note, yes, I'm drinking sparkling water. I'm trying to stay hydrated because moving is dehydrating. You can't see it. I'm drinking the Topo Chico lime with mint. I will say there we go. My sparkling water of choice is always going to be a Topo Chico. I think their bubbles are bigger, which for me is great because I don't drink a lot of carbonated drinks. So sometimes like little carbonation hurts my stomach. Topo Chico, it's where it's at. Please sponsor me. I'm a huge fan of yours. The glass bottles are preferred, but the flavored ones come in the tin. I'm a big
The hard
fan.
seltzer Topo Chicos are good too. They're very good.
They can do
Some
no
of my
wrong in my
faves.
book. They can do no wrong in my book. All their stuff is consistently good, consistently slappy. But the mint lime water, currently my favorite, 10 out of 10. Clark, what about you? What are you drinking?
I'm drinking Chicago's finest, an old style.
Classic.
As you guys know, I'm obsessed with Chicago and my girl is from there. So to Kristi's point about the Montucky cold snacks with, would you say,
a fireball shot?
Fireball.
Yeah.
In Chicago, you would do a shot of old style with Malort, which you guys probably don't know what that is. It's the best
I've had
thing
one.
ever.
It's disgusting.
It's the best.
It tastes like motor oil.
Yeah, it's not for me.
What type of liquor is that?
It isn't. It's
okay.
It's like an abnormality.
It's in the family. It's in the family of Jägermeister and
it's absinthe and whiskey.
Yes.
No,
it's not.
That is a good description.
But if you hate it, it may as well be.
I took a shot of that at a White Sox game. And then that was the first time I had it. And I was like, wow, this is a moment.
And a week from now, you'll have already taken another shot with me.
No, another one? Only because it's your birthday.
So here's what it is, Kayla. I can give you we're going to be informed on this podcast. It's a bitter wormwood flavored liqueur and the unofficial drink of Chicago, known for its unique and often polarizing taste. You heard it here. It is pretty polarizing. But it's a traditional Swedish spirit, and it's kind of like a bitter schnapps. And it was brought to Chicago by a Swedish immigrant. It's intensely bitter and herbal, which I think is kind of where you're getting the absinthe notes. And some say that it tastes like sucking dandelion juice through a straw made of car tires or an old shoe.
So I was not far off with it tasting like motor oil then.
So there you go.
Wow.
I love it.
That's specific.
Yeah. It's...
Oh my God.
Very cool.
Addie, I'm sure you have so many questions about Title IX, probably specifically.
I feel like most of my thoughts with some of the Title IX conversation, and Kristi, I just want to give you kudos. Typical law clerk style of giving us an educational experience on Title VI, Title VII, and Title IX. I am very worried, I think, with, I think it's kind of twofold. I think there was pressure, I think, under the previous administration, as you articulated, to push Title IX in a direction with current jurisprudence about, the direction Title VII is headed. I'm equally worried about what's going to happen with the future of Title IX cases and kind of where that's going to come down in terms of values of the current administration, the effect that's going to have on campuses, in the same way that I'm focused, I'm worried about that with Title VI stuff as well. Title VII stuff, I am very worried about. That's kind of something I've been thinking about.
I mean, Addie, though, I feel you. You're concerned about the future of these regulations and where it's going. And so, I was asking Kristi, what can you get from utilizing or trying to get justice through these avenues that you couldn't get through just like
like an action,
like a
otherwise.
misconduct complaint to your university, right? Like, don't universities have like codes of conduct?
Can I
Please,
answer that?
yeah.
I'm going to try. And Kristi, you can tell me if I'm right. My understanding, because Kristi and I did work in student misconduct together when we were law students. We did. Kristi helped me get a job while I was a law student. So there's some lore of the friendship for our friends who want to know about our history. But my understanding, I think it's kind of and Kristi, please feel free to jump in at any point. My understanding with like kind of the avenues of like misconduct, Title IX, and then also just like other legal actions is really, Kaylee, I think your point was really excellent in terms of like, what is the relief you're after? And also what is the like complaint stemming from? Because certain complaints have to go through a certain like department or like a certain box if you're seeking relief at a university level. So misconduct, usually there's different types of misconduct, but if you're wanting something like sexual harassment or something like that, that is a Title IX action. So you would be routed through Title IX. My understanding of why you would do that instead of necessarily go through a different legal action is probably twofold. You might want some relief immediately from the university level in terms of having protection from those people immediately being in class with you, say like a person who harms you as another student. Also, based on Kristi's excellent point earlier, you might want to go through the Title IX action first because it allows you to essentially get evidence potentially that could help you in a criminal case. So if you're wanting to have somebody who harms you, build a record there, you might want to pursue a Title IX action before you then, work. And you might be in communication with, the local police during that process anyways. And that could help you with pursuing that person being prosecuted. Most misconduct stuff, my understanding was when I worked in misconduct with you, it's like, it's very clear in terms of what the action is, like what the nature of the offense is. And then it becomes either like a regular student misconduct issue or a Title IX issue, depending upon the nature of what the problem is. I think depending, and Kristi, I think this is where it kind of goes the other way, depending upon if a student is also found in a Title IX action to violate university policy, they then could also be pursued for like a misconduct issue as well. So sometimes they go hand in hand, but usually you get kind of routed one direction or the other based upon, I think, the nature of the complaint.
Yeah.
Well,
I agree with all
was
of that.
saying like that there are requirements now for hearings and cross-examination. And I'm just thinking like from a victimized party's perspective, if they don't necessarily want to go through that whole process and hearing, would they have an option to go through another avenue in order to obtain any kind of relief? Or they can only get okay.
Yeah. So in the Title IX process, you can pursue informal resolutions. Like we've been granted the ability to, and I don't want to say it's kind of like this unfettered ability, but they don't tell us what an informal resolution is. They just say, if you want to engage in informal resolutions, you can. So every institution does it differently, but some schools do like shuttle mediation. So you go into informal resolution, you are talking to an assigned mediator, you're figuring out what everybody wants, and then you reach an agreement at the end of it. Sometimes it involves restorative justice. Like if we feel like we can put these two parties in a room and that's safe for everybody and everybody consents to that, and we feel like there's some real potential for the respondent, the accused party, to actually get something out of that restorative justice and out of that, some schools call them restorative justice circles, and we have everybody kind of sitting and talking about something. That counts as an informal resolution. Some schools do plea agreements, more or less. I mean, that's not the way that we would want to call it. Sometimes we call them mutual resolutions. Sometimes we call them acceptance of responsibility resolutions. But essentially, it's a plea agreement, and it says, you will be found in violation of the offense as we charged it, but here are all the things that you would have to do. And as long as both parties sign off on that, then we avoid the hearing and everything else, really. So there's ways to get that, but if you have a true Title IX offense, it falls in the jurisdiction, it's under the level of severity, and it's the type of conduct that's prohibited, you cannot get that resolved under any university process except for Title IX. So you can't say, hey, the student conduct process is way shorter. They're going to give me a resolution in 30 days versus Title IX cases can take 9 months to a year. I mean, that's not uncommon. Sometimes they take longer if the investigations take a long time. But that's not an option. We can't take you out of Title IX. So your options are either, you can engage in some kind of informal resolution, or you can go through our full process, or as a complaining party, you do have the ability to withdraw your case. So in order for us to proceed with a Title IX case, we have to have a signed formal complaint. And so either the complainant has to sign that for us, or I sign it as a Title IX coordinator. Title IX coordinators have the authority to sign stuff on behalf of the university if a victimized party doesn't want to sign one.
So you kind of have like prosecutorial discretion.
Yeah, we decide pretty much whether a report can move forward into a formal complaint. So in our system at Penn State, you kind of have two options. Like, you as a person reporting the offense can write and sign a formal complaint through our website. Like, you can just do that. If that's what you want to do, you can do it. I would say 90% of the time, our investigators are meeting with the complaining party, getting more details about what might have occurred. Because sometimes people are like, yeah, my boyfriend hit me and I want to report that. Okay, that's dating violence, probably based on our definition. And then they come in and they're like, well, there was this one time he sent my nudes to a friend. And then there was this other time we were at this ski trip and he like pushed me down. They start coming in and they start explaining all of these other things that are going to qualify as Title IX offenses. And then we write the formal complaint, like my investigators write it and we send it to the party and they sign it. But, if we meet with a student and we're like, yeah, what you're reporting to us is not necessarily a Title IX offense, we either, choose not to proceed with a formal complaint. We connect them, because sometimes there is stuff that's like, this isn't stalking, but maybe it's unwanted contact, because the bar for stalking is pretty high. But if you have somebody who's, bothering you in a different way, that could be a student conduct code violation. So we can still get you some redress, but it just depends on where it's supposed to go. But you as a complainant can't decide to take your Title IX offense somewhere else on campus. Going off campus, you can go through the criminal process kind of parallel to Title IX. That they do intersect at some points, but for the most part, it's pretty parallel. But if you wanted to sue your institution for violating your Title IX rights, you can't sue the institution until you go through a Title IX case. So you have to go through a case from front to back to get any kind of civil remedy. And that's pretty common, right? You have to exhaust all of your administrative remedies before you can seek a civil action. This is the same thing.
I'm so curious about like your big picture perspective about certain things. Like, are there frequent flyers in your line of work? Like, are there people who just like are constantly being accused of sexual misconduct?
I would say,
and is that many?
No, I mean, I would say in my experience, both as a person who's represented those people and as now, and I've only been in this role since November, so I'm still pretty new to my role at Penn State, and just who could be a frequent flyer over the past 4 months is different than the past 4 years, right? But in my experience of representing those accused students and in what I'm in now, I have seen frequent flyers be very rare, not altogether impossible. You can sometimes spot patterns, right? Patterns of behavior. Like, maybe you've got like some student conduct offenses that didn't rise to a Title IX case, but now the Title IX offense, it's meeting our bar. And so now we're seeing something that maybe has been taken care of as like a lower level offense, right? Like you have a physical assault, you punch a guy at a bar, right? Like that's pretty common in college campuses, like boys getting in fights at bars. Say there's some physical violence there that's been processed through student conduct, and now I've got a report that you've hit your girlfriend. Okay, so we got a pattern of physical violence, but we don't have a pattern of domestic violence necessarily. So that I see more often. The the kind of what Addie was talking about in the difference between where something goes on a campus, sexual assault, that is only going to be, and I kind of talked about this, but a sexual assault, a rape, a non-consensual penetration, non-consensual touching, that's going to be Title IX only in certain circumstances, right? So it's got to happen on campus or under university control, and it has to be severe, pervasive, and objectively offensive. So talking about the effect on the party. If that same assault happens in an off-campus apartment, it is not a Title IX case. So we don't have to process it as a Title IX case. That being said, a lot of larger institutions will treat all Title IX offenses the same, regardless of where they happen. So at University of Oregon, we did this, and at Penn State, we do this. But if you have a sexual assault that happens in an apartment and it was only severe or pervasive or objectively offensive, like it's only one of those things and not all three, we will still give you the Title IX process. So you still get assigned an advisor. You get access to all of the accommodations and support measures that you would be entitled to under Title IX. We treat it as a Title IX offense, but we charge it under Policy 91 instead of Policy 85. Like that's the only difference on our end. And like I said, University of Oregon did the same thing. A lot of big system schools will do it that way. One, it's easier on administrators, right? Like you're not adding a new process in there. You know, you're not having to treat sexual assaults differently depending on where they happen. You can just treat them all the same. But for the complainant, it may not necessarily be the route that they want to go down, but we can still offer informal options, right? It still doesn't mean you have to go through this whole thing and go to a live hearing, but you can. So that's also just a caveat there. A lot of schools choose to give that extra protection because frankly, it's just easier for us. Like when we get a report that said this person assaulted me or, this person took me home in an Uber from a bar and raped me, we don't have to figure out where you ended up in that Uber. We can just give you the protections and the accommodations that you're entitled to.
Speaking of like getting assaulted in an Uber, for example, I'm thinking back to the conversation we had with Moxie Rose, and we were talking about different like sexual trends and popular themes in pornography and how that like impacts our culture and people's behavior and potential like criminality, I guess is what we were talking about specifically. So I guess my question for you is, have you seen any have you noticed any trends there as far as like
I guess as far as like how viewing pornography or just in general like sex education affects my line of work, because that I think I have a better answer to. Essentially, there's a book out that I'm in the middle of reading right now, but it's called Sexual Citizen. And it was authored by Dr. Jennifer Hirsch, and there's another author on there. I can't think of his name off the top of my head, but I saw Jennifer Hirsch speak at a conference that I was at in October, and she kind of came up and was like our keynote lunch speaker at this conference I was at. And I hadn't heard of this book, and I had like literally was at this conference on a Wednesday. That following Monday, I was starting at Penn State. So I was very much in the transition to my new job. And so she was talking about this book and how relevant it was to thinking about sexual assaults and how to prevent that in college campuses. And so I was like, okay, well, that's piqued my interest. I ordered the book while she's talking. But she said that proper sex education has the highest effects on being able to mitigate sexual assault. So if basically her statement was, if you teach men how to have good sex with women, you eliminate sexual assault by 50%, like
what?
50%.
Damn.
Yeah. And she's like, that is vaccine level. Like if a vaccine is 50% effective, they will push that through the FDA, right? But our culture is so fascinating. And even when like we were growing up, it's, most of it's abstinence only, right? Like we didn't have proper sex ed because the religion is getting in the schools and interfering with the government. And so they're telling us they can't teach us anything about sex ed. And because of that, that has increased the sexual assault, right? Because, there are definitely these frequent flyers and these quote unquote bad guys, right? Of people that are just going to assault people because they have the power and that's what they want to do. And they're terrible people, right? Like that happens. And my clients that I used to work with, every single client I had in a Title IX case, it was their first time having sex with this person. And they met on a dating app.
Really?
Yep.
Stop. That is so fascinating. I think we just need to take a second and appreciate that.
Yeah. I mean,
virgins who met someone on a dating app.
Not their first time having sex. Their first time having sex with that person, Kayla.
Yes.
So
some of it is...
Might be.
Yes.
Yeah, I'm sorry. Sorry,
no, but
it might be their first time too, but
it could be both. Yeah. I mean, this book talks a lot about people who it was their first time having a sexual experience and it ended up being an assault. Like they were having sex with someone who it wasn't their first time, and they didn't, as like the victimized person, they didn't know how to communicate consent or boundaries or anything like that, and they experienced assault. But I see this a lot in my job now, but it's not uncommon. The most frequent flyer action I see is like people meet at a bar or people meet on a dating app. There's alcohol or drugs involved. They go home, they have sex. Everybody thinks it's fine. But then the next morning when people are sobering up, they're like, I didn't agree to that, or I had no capacity to be able to consent, or I talked to my friends about how weird this sex was and turns out I was assaulted. Like that happens more than anything. And so part of it has to do with like, we are not teaching people how to talk about things, like, and younger generations, they're not used to even, and I don't want to sound like an old person here, but like they're not used to talking to each other. Like they're used to interacting in another space or in a digital space. And so having to confront someone about something that you don't want is very hard. And it's also super hard to do if you're naked in bed with someone and like you've consented to everything up to that point, but now you're not going to consent to digital penetration, right? Like that happens all the time too. Like I consented to all of this other stuff, but not this one thing. And the person that you're with, maybe you communicated that to them. Maybe you thought you did. Maybe they should have understood and didn't, right? There's so much nuance there. And truly, if people knew how to have better sex, you would have less sexual assault. This is what it's a main argument in this book. It's not the only argument. They explore like 3 different types of like this sexual, like your sexual citizenship, your sexual geography. They talk about the fact that we have 2 twin beds, 2 desks, and 2 chairs in every standard residence hall room. And you take a person back to your room and they're not going to sit in the chair at the desk because that's kind of awkward. So you all are sitting on the bed together and then all of a sudden you're making out and all of a sudden you're touching and all,
That's a good point.
Yeah. Shared living spaces like fraternity and sorority houses, like it's kind of the same thing. You only have the opportunity to have sex in this building because it's the only place where you have your own room to be able to have sex. There's a whole lot of stuff going on in that book, but it really points out a lot of things. It's like, yeah, we could fix sexual assault in some pretty simple ways. It doesn't fix it entirely, right? Again, it doesn't eliminate this idea that this thing is not going to happen. But if you could have good sex and you knew how to communicate what you wanted in sex, that would make a big difference. And I think we don't get that in porn, right? Like, I think there's a lot of behaviors in porn that's just like people are doing things to each other and not talking to each other, like first off, or the dirty talk that they might be having is not like asking for consent. They're like, baby, does that feel good? Like that's, that kind of thing. Yeah. I mean, it's like, they're like, you like that, huh? And it's like, that's not asking for consent either, right? Like it's not even close. And so, yeah, I mean, I just think the culture around it too, it's also, it's hard to say yes or no like that. And I think that's also a misconception too, is that consent can only be given in words. So sometimes I've seen cases like I represented a client in a case like this where he said she was giving me every indication that she wanted to have sex with me. Did she say yes, she wanted to? No, but she took my pants off. She gave me a blowjob. She took her own pants off. She got back into bed after she took her pants off. She guided my hand down to her crotch or what, like any number of things like that. Those are behaviors that signal consent. And a lot of university policies, everybody defines consent differently. I'll say that. We have no standard, like Title IX doesn't give us a definition for consent. They do not tell us how to define that. So we all have these Frankenstein definitions of consent where we're like, hey, this worked really well in this other campus. Let's add it to ours or something, But most of these policies are calling it affirmative consent. And it's not just through words, it's through actions. but those actions have to signal to a reasonable person that you've not withdrawn consent, because you can withdraw consent without using your words as well. Like if you're pushing someone off of you, you're not saying no, but you're trying to push somebody off of you, that a reasonable person should know that means we're revoking consent. So it goes both ways, but that's also a big thing I see is victimized people are saying, well, I didn't say yes. Okay, well, but all of these other things happened. Like that's just an education issue. And so again, it comes back to how are we educating people? We had say no to drugs when we were growing up. That was a very verbal thing, right? Like say no, don't do this. And, see something, say something, right? Like we experience all of that, but it's all vocal, and younger generations are not engaging in that kind of conversation, but they're being told that that's what they're supposed to do. So when that doesn't happen, they also think, well, I didn't say yes to this sex, so he assaulted me because I never said yes. That
That's
may
so
not be true.
fascinating. So their understanding, a common understanding that you're seeing is that if you weren't specifically asked, then maybe you were assaulted.
Sometimes, it's not universal, but that is the area of consent that we see our students misunderstand the most, I guess, that I've seen. And
so interesting.
Working for two different institutions, I teach in Title IX to professionals all over the United States about this. And that's what we see a lot, just anecdotally. We have this definition of consent on our website, but it doesn't get the same kind of traction as rape. Everybody knows what rape is. That's a ubiquitous term. You can watch SVU and hear all about it. You can see it on TV. You could see it in the media. Like you know what that means, but you don't know what consent means, maybe. Or maybe you've transferred schools and you are at a different school that uses a different definition of consent. Like that also could create an issue. But yeah, a lot of it, I've seen a lot of cases come down to, was there affirmative consent? Not was there words, but was there actions that signaled that you as a reasonable person could believe that you had consent to have sex with this person?
How do drugs and alcohol play into that?
Well, most codes or conduct policies or Title IX policies, they will say that consent has to be freely given. It can't be coerced or by intimidation or under the influence of alcohol. You have to have capacity to consent. So if you are verbally giving consent, but you're blackout drunk, you never had the ability to give consent in the first place. So, for instance, if you have woken up in someone else's bed with no clothes on, and there's a condom on the bed, if that's part of your sex, condom on the bed. If you ask that person, did we have sex last night? Oh yeah, we had sex. It was great. Here's all the stuff that we did. And then you don't remember saying yes. You don't remember the sex happening at all. You file a Title IX complaint. You say, I've been assaulted. And then we start investigating it. The respondent might come in and say, no, she gave me the condom. She took my pants off. She said, yes, baby, yes. Like, all of that kind of stuff. If she doesn't remember, she never had capacity to give consent in the first place. But different definitions of capacity, right? Like ours requires the other person to know that the person doesn't have capacity to consent. Like you have to know that that person is inebriated. You have to know that that person has been drinking or smoking something or took something, whatever. But in a case like that, and we also only use preponderance of the evidence. So 50% plus a feather, it's very different than criminal law as well. You're more likely than not to get a positive decision in a Title IX case just because the standard is different in terms of the standard proof. But, I'll take that back. I don't know if you're more likely to get it. I just know it's easier to meet preponderance of the evidence for both sides than it is in a criminal case for the prosecution to meet beyond a reasonable doubt. That's just math. So it would make sense that there would be more Title IX violations in favor of a complainant, and maybe it doesn't go that way in the criminal court. That could be part of it.
I think it's so interesting the way that those overlap in terms of the criminal case and the Title IX case too, because the burden of proof is different. And I think as the defense attorney, your concern becomes limiting the record if you're representing the accused in the Title IX case, because the less that there is of a record there, it really,
yeah, and
I think helps you with the criminal case.
Yeah, and I had lots of clients when I did this work when I represented respondents where I would represent them on campus, but they also had a criminal attorney representing them off campus. And I would work with that attorney. And there was a few times where we decided it is best for you to not participate at all. Like, don't say anything, don't sit for an interview, don't provide any documentation, don't sit for the hearing, don't subject yourself to questioning. And as a party on either side, you can participate or not participate as much as you want. And sometimes for respondents, it's like, yeah, you need to protect yourself because in Oregon, it's a Measure 11 offense. So like you're going to jail, you're going to prison for a very long time if this plays out wrong in a criminal court. And I'm not going to let you talk in a Title IX case and that what you're looking at here is suspension for 2 years or being able to continue in school. And that is not a risk that you want to take when at least 9 years of prison time is on the table in an Oregon criminal court.
Yeah.
Kristi, you're amazing. We can't thank you enough for joining us. This conversation has been fascinating.
I'm so happy to have you back.
I mean, Kristi, just learning all about your job and the kind of work that you do at universities has just been fascinating. It doesn't, I don't think either of our work has ever crossed that line, but just learning about different areas of the law, I think is beneficial for all of our listeners and definitely for us as well. So, we
absolutely.
love you and we're so happy that you joined us. And I hope everybody has a great rest of their week. Cheers.
Yeah. Thanks, y'all.
Cheers.
See ya. Cheers.